Okay, I think we're recording now. Good afternoon, everybody. My name is Frank Myers. I am Deputy Legal Counsel for the Federation of State Medical Boards. Thank you for joining me here today. We're going to do a little overview of the status of artificial intelligence regulation at the state level. We'll go over a couple other topics, some really base AI foundational stuff, and then we'll try and fast forward to the really interesting state-based stuff. If you have any questions, I'd ask you just hold on to those at the end, but also feel free to type them in the chat as we go along. That's usually an easier way to track them and keep them going. So let's delve right in. Let's see. There we go. A couple disclosures first. This presentation is for informational purposes only and is not intended to provide legal or medical advice. The views and opinions expressed in this presentation are those of myself, the presenter, and do not necessarily reflect the official policy or position of the Federation of State Medical Boards or of any organization. If you're interested in seeing the official policies, I'll be referencing several throughout this. I always instruct or ask people to go check out those policies directly. Portions of this presentation, including the generation of images, were assisted by the use of artificial intelligence. We'll go over some demos, or some examples, I should say, of some AI tools out there and their outputs. Those are purely for informational purposes. I'm not endorsing any products through this. And then the use of AI in this creation, as I just said, does not imply the endorsement or validation of the content of the AI or its creators. Always verify AI outputs on your own independently. If you haven't heard that enough, I will reiterate it plenty throughout this presentation. A little bit about the Federation. At the Federation of State Medical Boards, we proudly support state medical boards within the United States, its territories, and the District of Columbia. We serve our boards as they fulfill their mandate of protecting the public's health, safety, and welfare through proper medical regulation. That includes the licensing and disciplining of physicians, physician assistants and associates, and also several other healthcare professions that are licensed by medical boards, such as, in some cases, chiropractors, in other cases, physical therapists, and many, many others, depending on the state and jurisdiction in which you reside or practice. Our top priority at the Federation is supporting our state medical boards in the crucial mission of public protection, and we do that through many mechanisms. We have a very vast and diverse support system that includes providing advocacy, policy, and communication services, technology information services. We provide educational programming through either our annual meeting or our yearly board attorney workshops, or through many of our online webinars and other online educational services. And then we also do several in-person events, most notably in the AI field. Last January, we at the Federation did an AI symposium in Washington, D.C., and we had a lot of attendees from across the industry. It was very helpful. And then lastly, we provide, I should say, our two last things are assessment services. We are partnered with MBME to provide the United States Medical Licensing Exam, and then we also provide licensing and disciplinary data to our members and to third parties.
It's huge.
So
we have to show doubt.
So what are our learning objectives for today? So we have several learning objectives, but our four core ones are, we're going to look at understanding the trends in state AI policy reform. We're hoping that you walk away understanding a little bit about the impact of AI on healthcare delivery and practice. Give some advice, and hopefully you can walk away with some practical strategies for navigating evolving regulations, and they are evolving. And then hopefully some tools and resources for staying up to date. This space is again very evolving, very large, very massive. So I have no doubt I won't touch upon everything. But hopefully we'll give you the cores that you need to really understand from the state perspective how AI is being addressed. So before we get into how states are looking at AI, I do think it's important to kind of define what we're talking about, at least in this scenario as it relates to AI. And really, depending on who you ask, there could be really many, many types of responses to what do we mean by what is AI. These are all, of course, AI-generated images, and so this is the AI giving us an idea of what it thinks of when we give it a prompt of a group of scientists and regulators trying to define the term artificial intelligence. But really, and artificial intelligence is very massive. You've probably heard many of these terms: artificial intelligence, augmented intelligence, machine learning, Gen AI, generative AI. natural language processing, large language models. By now, you've probably also heard of terms like multimodal, fine-tuning, digital twins, and a lot about agents. And generally, AI is just an umbrella term for technology that can perform, quote, intelligent tasks. For decades, AI has mostly been used for analytics, but now we've reached, and I like to refer to those as what I call algorithmic um, or analytical AI, data-based AI. All AI is really data-based. But what's really revolutionizing the space now, and what's causing a lot of regulatory interest, is the ability of these models to now perform in these intelligent human-like tasks through generally what is called generative AI. And so we're going to kind of focus on that aspect and how we are looking at regulating those types of AIs. Obviously, there will be crossover into the analytical or algorithmic AI, so things like substance detection models and things like that. But really, that is what we're focused on, is those ability of these models to essentially replace licensees. And that's how this presentation is focused at, is we're looking at this from the medical board perspective and the perspective of regulating professions, which are now being impacted and really revolutionized by AI. But the big thing to remember there is AI is not new. So why now? Why is it all popular? And that's really the breakthrough of generative AI. I won't go into the scientific details, but basically, here's some links to an article from the Washington Post, as well as a link to an article, Attention is All You Need. This was actually a paper published in 2017 from Google Research that introduced a new method of machine learning called transformers. And really, that is what transformed, no pun intended, the AI space as we see it today. These are two images from that Washington Post article, and it just really highlights the differences between we'll call them the old AI learning models and the transformer model. And really the main thing you need to understand is that the prior models would look at things sequentially and how words connected, and these new transformer models are really looking at how all of these words and phrases are related to each other and how they make these connections to generate this generative content. For those that are interested in learning more, I've got there's two sources here, and a copy of these slides will be available either as a PowerPoint or a PDF, and there'll be some links in those slides. But these are two resources that if you're interested in learning about the technical aspect on the left, it's called a Transformer Explainer. It dives deep into the science of how transformers work, but through a fun, interactive kind of example. But if you really just want to have a more digestible read, more high-level read about AI and how it kind of is impacting things, here's a book from Janelle Shane called You Look Like a Thing and I Love You. And one little tidbit about the title, it comes from the author's experiments in creating a large language model that could create one-liners. At the time, the author was out in the dating scene and thought this would be an interesting way. And so one of the outputs was, you look like a thing and I loved you. And she thought that was one of the better examples out there. So it led to a very interesting title and quite entertaining book. So the last thing I'll say really on transformer models is that other than this architecture is really transforming the space, is that there's just a vast multitude of models out there. You've probably heard of and used ChatGPT or Claude or Gemini or maybe one of the many others, but there are many, many, many out there. They vary in strengths and capabilities, and it's not a day, week, or month goes by without an advancement or a new model coming out that promises, and sometimes actually fulfills those promises on transforming the space. All of that, though, is only capable because of the data. And I do need to highlight the data aspect of this, because a lot of how AI is being regulated is not through necessarily the models themselves or the outputs, but through the development and construction of these models. And as many of you have probably heard or aware of, garbage in, garbage out. Bad data in is going to lead to bad outputs. And so only by ensuring that we have good quality data can we ensure that these models are being developed free of bias, with the correct data and things like that. And so it's important to understand, where is the data coming from? How is that data being verified as good data? How do you know that the machine or the model is being trained on quality data and accurate responses versus inaccurate ones? And then what role do humans play in this? There are concepts of reinforcement, human reinforcement, learning by human reinforced feedback, as well as machine feedback. I'm probably butchering those technical terms, but essentially that machines can learn through the feedback that's either provided by humans going through and annotating things, which you see in companies like Scale AI, which employs thousands of annotators around the world, or they do it through a machine model, office many times referred to as adversarial network training, and they kind of look at providing that feedback that no, that's wrong, no, that's right, and then the model changes itself to become more accurate or better at what it's doing. You know, the big thing, again, other than garbage in, garbage out, is that there is a huge network of companies, kind of a ghost workforce, if you will, of annotators and companies that are out there that are helping to really go through and sort through these data sets to make sure that these models work. And I cannot lie, as someone who's tried to build some tools, the amount of data that you need and the amount of time that you have to spend on cleaning up that data is quite huge. So I think this is one of those things that we see at the federal level or at the international level is being addressed. But it really addresses the development of these things and not how many of you as a professional regulator are going to address the actual use and implementation of these things. So let's get to the uses of AI. I think it's important to understand what you're looking to regulate and what those tools are and how they're being used before we can actually understand what laws we need. This slide is really just an overview of probably two of the biggest actually health AI, if you will, outside of health systems, which we really don't have a very good eye into, and we really still don't have a very good eye into what's going on at Google. MedPalm. MedPalm is Google's most recent model. It was released in 2022 and updated 1 year later in 2023 to MedPalm 2. It is a family of foundation models fine-tuned for the healthcare industry, and it's available on Google Cloud to select customers. Generally, it is something you have to get permission, to get access to these models so that they can be integrated into your workflows. Palm, for those that may not be aware of, and these model names get quite ridiculous quite quickly. Palm is the large language model that was originally before Gemini. It was a model developed by Google to provide a general large language service, and then Med was fine-tuned and focused on the medical space. There's several industries out there that are testing and moving at Med LM into production. HCA Healthcare is looking at how it can use a transcription model similar to, maybe you've heard of DAX from Microsoft and Nuance. Google has Augmetics, so they're looking at how that can help physicians. A company known as Vennsci is looking at building MedLM, into the Ascend platform to increase the speed and efficiency of preclinical drug research. And then Google is working with many others, as well as in partnering with Deloitte, to see how they can reduce friction in finding care through interactive chatbots, patient interactions, experiences, and outcomes. So generally, there's a lot of space on how these tools can be used in healthcare. To give a brief understanding, I can move my slide. There we go. This slide here is really to give a brief understanding of how quickly these models advance. You see here two benchmarks that Google itself has provided for MedPalm and then MedPalm 2. And essentially, these are trying to say that both MedPalm 1 and MedPalm 2 passed, and there's the passing line, that's 60%, what they call the approximate medical pass mark of USMLE, quote, questions. And I highlight questions because neither of these models actually took the United States medical licensing exam, but they did answer a lot of questions that were based on a Med MCQA data set. There's a lot to unpack there. If there's one thing I have to say to regulators, my biggest concern with all of this are the benchmarks that are being used to test the accuracy, the reliability, and the efficacy of these tools. There are a lot of internal benchmarks. They're used on their own quality metrics, and they don't necessarily correlate to a one-on-one result in actual practice. That said, though, I do think we have to acknowledge that if both of these, MedPalm and MedPalm Tomb, are using the same benchmark, the same data set benchmark. And in the course of 1 year, we saw an increase from a 67% accuracy to an 85% accuracy. So I do think that there has to be an acknowledgement to the speed at which these systems improve and get better and get enhanced. This slide is really just to, again, acknowledge that Google's medical AI chatbot is already being out there in hospitals. This is an article from TheVerge.com about how the Mayo Clinic has reportedly been testing MedLM, and or at least a version of it in their clinic since April of 2023. Google is not the only one. At the Federation, we've met with representatives from Duke Health and others, and we know that there are medical models that have been used in practice for many, many years. And again, most of them are in the algorithmic nature and the predictive outcomes nature in terms of sepsis, things like that, but not in the generative space. And so what we're really interested at the regulatory level is the role these models are, being incorporated into clinical practice and to kind of serve as a quasi-clinician, or what is known as clinical decision support. So those are the things that we're really looking at. I mentioned DAX already. DAX is known as Dragon Ambient Experience. This is a tool that's used to transcribe clinical interactions and then turn them into valid and viable medical notes. And so DAX is a product from Microsoft. I mentioned also Augmedix from Google, but there are many, many others out there. And this is a space that is kind of exploding because it's one of those areas that AI is proving to be very, very helpful, useful, and for the most part, accurate and reliable. But it is not without its own faults. It's not perfect. Most recently, there was a lawsuit settled, or I shouldn't say a lawsuit, but a settlement entered into in Texas between the Attorney General and a private company that had offering its own clinical dictation software and clinical documentation software. And apparently the company had claimed a less than 0.00, and to forgive me on where the decimal point placed, but a very small chance of hallucinations, which was alleged to be not correct. And ultimately an agreement was reached between the Texas Attorney General's office and that entity to basically remove those statements because they were not accurate. And so those are the things to think about, is that even with these transcription tools, especially in the medical space, it's not just the accuracy of translating or transcribing, I should say, the word or the text, but ensuring that you're transcribing it into the valid medical note or prescription. There's jokes about physician handwriting and the ability of pharmacists to read that handwriting. I'm wondering if we're going to start seeing some jokes about whether or not the AI can understand even what the prescription the doctors are saying, depending on the AI model we're using. So even in those situations that seem very benign and seem like they're not going to cause any real problems, they're just not copy and paste. There is the physician that has to be involved in that. Here are just some examples of AI models that are out there in the open space. These are from OpenAI that has its custom GPT store. And there's several GPTs that are out there that are developed by users that can be really accessed by anybody. Here's an example of what's called Dr. Soap Note. And it was used to create soap notes. And I have no comments to its accuracy, but I will, and I don't know how well you can see this, but again, there'll be the copy of the slides. But here's an example I asked this GPT to write of a soap note, and you may not be able to see it, but I did not give it any patient information. I just asked it to write a soap note for a patient with asthma exacerbation. And then it completely made up a note for a 35-year-old female, and I gave it no demographics or anything like that. So this is a bit of an older model, but I think it's safe to say that the safeguards really are not in place on this kind of model. And so, from the general public going in and using this, or even from a clinician, what are they gonna, if they don't have experience or education in this, how are they gonna look this and what are they gonna take away from it? So those are just, again, things as a regulator, things as a user to be aware of when you're using these tools. What are they capable of, and how prone to hallucinations are they? So this slide here is really just to give you an idea, all of the major players between Microsoft, Google, Meta, Here we have Anthropic. They all have their versions of policies or principles to guide the development and implementation and use of these tools. But they're all internal policies. None of them are set in stone. This last one, Claude's Constitution, which comes from Anthropic, is a bit more interesting because it's meant to be part of the model's test development and training. So that the idea is that it's part of what it is. But if you know this space, you know that these models can be fine-tuned and with enough data can have things removed from them. And it's not always the most successful, but it is possible to remove those safeguards and get unfiltered models. But again, these are all to show that these are policies on best practices, responsible use, and none of them are set in stone. And OpenAI is probably, the best example of showing, having these things in place and then removing them. And this isn't unique to OpenAI, but this is just an article that I'm showing. Many corporations in this space, in this sphere, have kind of pushed back or taken a little bit of a step back on these safety teams, on these ethics and best practice teams. So this is really just to highlight that none of that is set in stone, regardless of whatever guidelines or best practices or principle that these developers and these institutions come out. They are not regulations. They do not necessarily govern any of the model's behavior necessarily, and definitely they're not overriding, for the most part, the terms of use that you agree to when you're using these models. And arguably, probably even more important than those principles are those terms of use. So if there's one takeaway, it would be that these principles really aren't worth much on what they're printed on. You really need to look at the terms of use and the privacy agreements when you're interacting with these models. So that brings us to regulating AI. And I think we've seen a lot now about why we need to regulate AI, but I do think it's helpful to kind of go over it a little bit more detail, addressing, the impact on society, the risk of bad actors, the need for education because of the lack of understanding of how these models work and the role of professional responsibility in that. The need to be disclosing these models and get a consent from those people that are using them, especially in the healthcare space, and then how the standard of care in healthcare may be impacted by what these models do. So first, there's the impact on society. This is a slide that was taken from the McKinsey Global Institute. They did an analysis about how vulnerable AI will make the most educated workforce. And I'll let you all go over the statistics here in specific, but two major takeaways from this slide is that one, AI will automate tasks previously not thought possible. So think advanced writing, document review, content summarization. Previously, any kind of automation did not impact these industries. But with AI, they are now seeing a significant impact, which is displayed here with the black bars. But we also see in the white bars that AI will impact those industries that have generally been pretty impacted by automation. And so the second takeaway is really that AI will impact everyone. And when AI is impacting everyone and has such a massive impact on society and in particular their workforce, regulation is going to be needed. We've always seen regulation when anything comes about that it is needed. The question is really at just what phase of this will it come in? Will it become before the major harms or will it come after major harms? So major harms. I highlight here two examples of what, really one example of what I call the bad actor problem. Hospital systems, and we hear a lot about AI assurance labs in the space or these safeguards that are placed in hospital systems. Hospital systems are not really what keeps me up at night. They have the incentives to make sure they do this right, and they have the money and they have the general infrastructure. There's many things that have to be worked out and finessed and figure out how to be done, but it is not in the hospital's best interest to provide bad patient care. They don't want a bad doctor. My concern are these independent actors that are out there putting out models, just general public facing models on the web. As you see here, Dr. Gupta and Dr. McGrath. These are two AI chatbots. Dr. Gupta is a medical doctor chatbot that purports to be a doctor, and Dr. McGrath is a veterinarian and purports to be an AI vet. And the idea is that you can put in your symptoms, and you can see here with the Dr. Gupta, you can even put in core demographic information. You can put in your weight, vitals, lots and lots of information. No idea about the privacy that comes into this, but the idea is that it would take it all in and then provide you with an output. As again, I said, I'm not, I'm not speaking to the accuracy of these models, but I will say that the model outputs on this one were false. They're straight up false. Even between just asking it who it was, it would say Dr. Gupta, but if you pushed it on where it was licensed, it would say I'm licensed in this state or I'm a doctor this. So at the time, and again, this was played with probably about a year ago, not very good. But these come from an individual, Martin Shkreli, this is an article from the Verge.com as well. He is known as in some spaces as a pharma bro. And he was a former CEO of Turing Pharmaceuticals, and he's infamous for increasing the price of the drug Daraprim from about $17 to $750 per pill. He's ultimately convicted of securities fraud, which was unrelated to that fiasco, and he was sentenced to prison, and he ended up spending, I think, about 7 years behind bars. And when he got out, it looks like this was one of his first projects or one of his early projects and investments. So these are the kind of actors that I'm concerned with, and that as a regulator, I think they're going to be the ones that are going to pop up the most are these websites, kind of like purporting to be telehealth or telemedicine, but are really just bots on the back end spewing out accurate, inaccurate, who knows what. And it's really going to come down, unfortunately, to knowing which are those legible, credible companies and institutions and which ones are the not. And that goes again to my earlier statements about education. So bad actors, again, are another reason to be aware of in the space. There's also the issue of professionalism and ethics. There's a lot of just, lack of a better word, laziness. Not necessarily bad actors, but people that, just kind of fell into the trap of automation bias or not knowing what they're using. We've got two articles, one from the New York Times and one from The Verge. The Times article highlights something that's actually occurred quite, unfortunately, more often than we would hope in the legal space. Attorneys treating ChatGPT as some sort of legal research tool and just asking it for case citations and then copying those into legal pleadings, which then get caught because the law, unlike healthcare, is an adversarial profession. There's always someone trying to catch you, trying to undermine your arguments. And so no surprise, they did their own research and found, well, these links and these citations are not real. They're not legitimate. And so this brings up a big problem with professionals, is that it's not just, using the tools, but are using them properly? Are you doing your professional due diligence and duty in using these tools, ensuring that whatever output you get, they're accurate? This here is a quote from that article from the attorney in question saying, "I heard about this new site, which I falsely assumed was like a super search engine." That statement alone, from a professionalism and ethical obligation, is a huge red flag. The assumption that an attorney there's just so many things wrong with this. And so licensed professionals, and this is something we'll talk a little bit here in a little towards the end about in our policy, licensed professionals really have a duty to ensure that licensed healthcare professionals that ensure that the care they provide meets acceptable standards. Really, this applies to all licensed professionals, that those services you provide meet the acceptable standards because you are the licensed person, you are the professional authorized to engage in that practice, not the AI, not the tools. They are just data points and tools to be used to perform those services, to perform that profession. And so it's very important. The second article there is about a defamation lawsuit that was filed against OpenAI for essentially accusations that were completely false, made against a radio host. Essentially, an individual had done some research, asked about some predators in the area or some criminals, felons in the area, and this radio host came up on a list. This is back in the very, very beginning of ChatGPT when it was brand new. A lot of guardrails have been placed in since then, so that you try not to get some of those same things, those same false level or those same high levels of hallucinations. They still do happen, but again, major tip: ChatGPT they're working on a search tool, a tool for individuals to use as part of their internet search. But to ask any of these AI models to give you an answer without a grounded data source. And what do I mean by that? But I mean by something for the AI to go look at. If you're just asking it raw, like you would say a first year intern, hey, what does the law say on this? And they just quote it to you. As a lawyer, you wouldn't just take that to the court. You would ask for the sources, the citations. So think of that. It's not necessarily a good idea to add a human personification to these tools, but that's a thing to think about, is that treat it like you would an intern. You wouldn't just take an intern's word and go for it. So you really do need to second guess and question these things. This slide is really to emphasize the need for consent and disclosure. There's a big, this was a very fascinating read about how, for those of you that may have a chance to go experience, Amazon had a few stores where you'd walk in, grab things on the shelves, and you walk out. And computers were watching you through cameras, and so it could identify you picked up that sandwich, and it would charge you after the fact. So the idea was a completely frictionless experience. This article, eventually Amazon shut it down, but they are selling the technology and leasing it out to other third parties, and they still use it themselves in smaller spaces, but they're just walkout stores. They're kind of ending that. And shortly after that, it came out that Amazon, part of the reason was that the AI didn't work. The Amazon was actually using humans to do all this work. And that is an over exaggeration and a kind of a misunderstanding of what is going on. Yes, there are human reviewers, but as you may recall, when I mentioned, there is a need for a lot of good data. And so garbage in, garbage out. In the beginning, when Amazon and other companies are developing these tools, they need humans to go in and annotate that data. So yes, humans were watching people shop to correct the model's outputs, with the goal of eventually getting the technology to the point where it no longer needed those humans. And so in all fairness to Amazon, this was largely an issue of people just not understanding how models are trained and fine-tuned. But at the same time, from the public's perspectives, they don't know. All they know is that they're being watched. And they know they're being watched, but what level of consent and disclosure is necessary in that kind of situation? And that's just a shopping situation. We're not even talking about healthcare. And so when we talk about consent and disclosure, it's not just about that you're interacting with AI, but how is that data going to be used? It's not just that immediate consent and disclosure for the use that leads to my own benefit, but the fact that humans are looking at that and using that information to then further train those models. Those are the things that we need to be thinking about and what is needed for consent and disclosure. This here is Luminetics Core, and this is I'm showing this to get at how the standards of care might be affected by the advancements in this technology. Luminetics Core, otherwise known, also known as IDXDR in Canada and previously in the United States, is the first ever FDA-approved autonomous AI diagnostic system. Luminetics Core uses machine learning algorithms to analyze images of the eye to make a diagnosis for diabetic retinopathy. And it's designed to do that without the need for any specialist to interpret the results. So it's not designed to provide, say, a set of data points like you would in an MRI or an EKG, X-rays, or anything like that, where an independent specialist comes in and says, this was above 300, this is below that, therefore you have this. Luminetics Core is doing all of that and making the diagnosis itself because it's doing things that just a human can't possibly do to that degree of accuracy. And so the question that it begins to get raised is what role or how does the standard of care get affected when we're using autonomous machines to create these diagnoses? And what role do regulators, as particular medical boards, play? I think in this situation, the answer is relatively straightforward. Luminetics Core can't then treat the patient. It doesn't have the ability to go out and write prescriptions. It can't, examine the patient. But that doesn't mean that with some of these models, especially with what's kind of coming to the fruition in what are called autonomous agents, what role they may play in the prescribing and healthcare systems. So this is an early example and quite a good example of a device and a system that went through the process. But again, this is one of the more complicated areas. What do we do when we get these models that start to really affect interaction, when Dr. Google actually becomes a really good doctor. Here's a couple other examples about AI being used to diagnose brain tumors on the operating table. AI-assisted colonoscopies reduce the miss rate by 50%. So when you're now actually hitting and being more accurate by 50%, wouldn't the standard of care almost dictate that you must use AI? So these are some interesting questions. And then lastly, we have here, this is an announcement about a company called Pearl that raised 58 million to help dentists make better diagnoses. I don't know much about this company and how successful it will be, but I highlight it because the founder expects the company to become a global standard of care within 3 years. And again, I think that's a bit of hyperbole and exaggeration, but we can see that a lot of these players in this space are looking to really upset the standard of care in healthcare and really in the industry, and they want to do it fast, and they want to do it quick. So where are the regulators on this? So we've got a very interesting regulatory landscape when it comes to AI. And really what you see up here are the two very drastic differences. On the left, we've got the United States, and on the right, we've got the EU. And on the left of the United States, there's really been almost no movement. There is no single regulatory entity in the United States that has oversight of AI. Instead, we're left with a patchwork of existing laws and regulatory structures through the FDA, through Health and Human Services, through the Office of the National Coordinator, and many different offices and regulators that cover their little pieces, whether that be data privacy, whether that be food and drug over device development or research. And they cover their little pieces, but none of them come together to regulate the final product. There's no single entity that's out there to say this AI must be shut down. So says the Office of AI. Not in the United States. And it doesn't look to be changing anytime soon in the United States. There's been a lot of talk. There's been some legislation that's been proposed to accomplish different things, whether that be for deep fakes, use of AI and medical insurance claims, things like that. But there's been no real large agreement that's been able to be reached. And at this point in the year, especially with the election, it's just, I don't expect it to happen. And we'll have to wait until the next administration, whoever they may be, to see if there's any movement on this space. In the EU, they are leading the way in this space. The EU had a unanimously endorsed EU AI Act, all 27 members, in December 2023. It's hundreds of pages long with a complex legislative process. I'm not going to go into a whole lot of details, but the EU is looking to regulate AI, through various mechanisms like transparency and disclosure laws, identifying and providing summaries of copyrighted training data that was used, and it imposes content moderation requirements on generative AI providers. So it is definitely looking to achieve those things. There's still a lot of gaps left. The EU AI law actually started before this generative AI craze, and obviously incorporated some of it, but there are still a lot of things that are going to have to be looked at, especially as these models continue to evolve and advance in this space. And again, not the United States at the federal level is behind, but that doesn't mean they're not doing anything. President Biden did issue an executive order on the safe, secure, and trustworthy use of artificial intelligence. This was actually a very surprisingly long executive order. If you've read a lot of executive orders, the problem with executive orders is that they're only valid for as long as the executive's in there, and they're only valid and have the enforcement authority of those powers already granted to the executive. So they can't do anything new, but they can instruct government agencies to look at how they're using AI internally, to look at how those they regulate are using AI, and to really help come up with some best practices and best standards. And in certain industries, actually coming out with regulations. Probably the biggest, source of regulations in this space in the United States is the Office of the National Coordinator. They regulate essentially EHRs, medical records. Sorry, I'm blanking today on the words. The electronic medical health records. And so they regulate that. And a lot of those record systems, like from Epic and others, are incorporating clinical decision support tools. And so through that mechanism, they're able to kind of regulate those tools and ensure that they include certain mechanisms and certain things in place to ensure that those products come out and they come out well and they don't harm the public. So if we don't have any movement on the federal level, where does that leave us? Well, we do have movement on the state level. So Utah has Senate Bill 149, which is now law. It aims to protect consumers from AI harms while still encouraging innovation. It holds companies liable for using generative AI to deceive consumers. It requires consumer AI like chatbots to disclose they are not human when asked. But it also mandates proactive disclosure in sensitive industries like healthcare. So if you are a healthcare provider working in Utah and you're somehow using, let's say, an AI to triage patients as they come in, because you are a licensed healthcare provider in Utah, you must proactively inform them that they are interacting with AI. Meanwhile, if you are not a regulated industry, if you're not a licensed professional, you don't have to proactively disclose that they're interacting with a chatbot. But if you are asked, you must tell them that you are. This law also creates an AI policy office to research the impacts on recommended regulations. But perhaps most importantly, and what is very interesting about this bill, is that it allows businesses to test AI with some liability protections in Utah by registering with that AI policy office. So I think that is I do like the idea of a kind of a AI regulatory sandbox, because there's a lot of these tools that we just don't know what they're going to do. And I think a lot of developers do want to get into the space and make some tools, but the regulatory hesitancy is it is slowing them down some. So this kind of law, I think, is one that could be helpful, but it is not the perfect solution. And of course, it only addresses, that use and development in Utah. And, to what degree we're seeing that then impact other states and the national practice. I'm not expecting a lot of change from OpenAI and others outside of Utah. I think the consent and disclosure stuff will be everywhere. I just think that's good practice. But whether or not we see the adoption of a more regulatory safe space, again, the sandbox, that'll be interesting to see. Another state that has come out with some legislation regulating AI, Colorado. SB 24205 introduces new legal requirements. This is also the law in Colorado. It introduces requirements and duties for developers and deployers of these high-risk AI systems. Think of deployers like as health systems. And to mitigate the risk of algorithmic discrimination. These requirements vary depending on a lot of factors that go into this, like how you're using AI and what your role is in the use, development, or deployment of those systems. But primarily, it's requiring implementation of some type of risk management policies or programs that are aligned with recognized standards. So one standard that's quite frequently referenced is the NIST, AI Risk Management Framework, NIST. So that is a framework and there's many frameworks out there, but NIST is really the one that's the primary one that everyone's following. And then it also mandates the conducting and maintaining impact assessments to identify and mitigate discrimination risks, which is what a lot of the concern. And I should say, for the discrimination aspect, these models are not inherently discriminatory on their own. Garbage in, garbage out. And so I think one of the most interesting things in this space is seeing the medical industry and healthcare in general having to come to grips with a lot of the data that they have and the underlying discriminatory underpinnings that led to some of that data and some of those historical conclusions that just are not medically accurate or medically factual. Another thing this law does is it notifies consumers or requires the developers to notify consumers when high-risk AI systems are used for consequential decisions. So again, I mentioned clinical decision support. And so in this situation, a healthcare provider would be required to notify a patient that an AI model was used to help make a consequential decision. And arguably, I would say this could extend to even those models that aren't generative. They're not meant to be like a chatbot experience, but could be a sepsis model. Depending on how this law is interpreted and really enacted in Colorado. So And then lastly, it mandates providing consumers with information on adverse decisions, data correction opportunities, and appeal processes in the use of AI in your care. So if, for example, an insurance claim, if an insurance claim is denied and it's used AI into making that determination, there's a chance to appeal that or correct perhaps inaccurate data that was ingested in making that determination. But perhaps the biggest state to be aware of and the biggest regulator to be aware of outside of the federal government is California. The size of California, the fact that most of these developers are located in California, and the economic power that California has really gives them a lot of strength in this bill that they have proposed. California Senate Bill 1047 in particular is the specific bill that I'm referencing here, and this is known as the Safe and Secure Innovation for Frontier Artificial Intelligence Models Act. Very, very wordy. But this is a proposed piece of legislation that's aimed at regulating advanced AI models to ensure their safety and then prevent potential harms. It was authorized by State Senator Scott Wiener. It looks to establish safety standards for AI systems that are in particular the most powerful and costly to develop. And it's really looking at targeting those with significant computational power and training costs that exceeding about 100 million. There's some interesting comments to be made about how they're targeting their models, because while I think in the beginning that makes sense, computational power and cost is huge. The reality is that a lot of these models, the foundational models, once they're trained, they can be untrained, and a lot of things can be done with a lot less computational power and money with a larger foundational model that is fine-tuned. So I do think there is some future discussions to be had about how we're going to focus regulation of these things. But this is really the biggest one out there right now with California. This bill has passed both the House and Senate in California, and it is waiting Governor Newsom's signature. I do not have a crystal ball. I looked up, I Googled searched right before this meeting to see if he had signed it. Still no movement, and I do not have a crystal ball on whether he will or won't. He's getting a lot of pressure on all sides, both from pro-AI and consumer protection advocates, to either sign or not sign this bill. It should be noted that Governor Newsom did sign a few other AI bills right before this one. Those bills were focused on what are known as deep fakes, AI-generated fake videos of people. It's focused mainly on protecting deceased celebrities, requiring approval before the use of their likeness in generating AI deepfakes, and really closes some loopholes that existed before. And so now you just can't generate it. You really do have to get the family or the estate's permission. But this bill would put a lot of responsibilities on the developers. And this is really kind of the major takeaway I would put out there, is that most all of these bills, these pieces of legislation, are focusing on the developers and trying to ensure that there are some things put in place on the development aspect to regulate these tools. That includes implementing cybersecurity protections, creating capabilities for a full shutdown, that the machine can be fully shut down if have to, develop and implement the safety and security protocols, conducting risk assessments, implementing safeguards to prevent critical harms, undergoing annual third-party audits, submitting compliance statements on an annual basis, reporting AI safety incidents, and many, many, many others. And the enforcement side of things, it provides that the Attorney General can bring civil actions for violations, and the penalties can include fines, injunctive relief, and also damages. There's also some whistleblower protections. It establishes a board of frontier models, which is very interesting. I don't know who they're going to get to sit on this board, what level of expertise they're going to get outside of the developers themselves. So that's very interesting. And then it also proposes a framework for a public cloud computing cluster known as CalCompute. And then it authorizes the Government Operations Agency to issue regulations on model thresholds, auditing requirements, and safety guidance. There's a lot to unpack in this bill. If you're in this space, there's so many developers are in this. I wouldn't be surprised if they're gonna, this bill will impact models outside of California. This will have a larger reach, I think, than California if it's signed. So it'll be interesting to see how this gets played out, especially considering that I think Newsom has to the end of September to do this. And with the elections and all the politics at play, it'll be very interesting. So talked a lot about the developers, what's going on at the EU, what's going on at the national level, and what's going on at the state level. And again, I said a lot of this is to focus on developers, but what about the practitioners? What about medical boards or professional licensing boards and those that you license and regulate? So we at the Federation realize that that's different. That's, boards do not have the resources necessary to regulate the development, implementation, or deployment of AI. Boards are focused on ensuring that those that they licensed are qualified to do so, and they're remaining professional and ethical in their duties. And so in April of 2024, following the work of the FSMB's Professionalism and Ethics Committee, the House of Delegates for the FSMB adopted this policy navigating the responsible and ethical incorporation of artificial intelligence into clinical practice. The main points to take away are here. Education is critical. Physicians should engage in continuing education to understand the benefits, risks, and implications of AI for patient care. And this should extend to all levels of education, starting at the medical education, but really going up through continuing education. And it should emphasize advanced data analytics and clinical applications of AI. Perhaps most important, though, is that we are very clear that physicians, and for those that are not in the medical regulatory space, your licensees are the ones that are accountable. It is your licensees that are authorized to engage in the practice of your profession. We don't necessarily license every tool or regulate every tool that our licensees use, but we do expect our licensees to use those tools in which they use to use them appropriately and safely so that they can provide quality care or services to those they serve. So at the end of the day, the physician, especially in the healthcare space, is accountable. AI can assist in clinical decision making, but physicians are ultimately responsible for that care, and they need to apply the professional judgment when using AI tools. Proper documentation of the rationale for following or deviating from AI recommendations really is going to be essential. And that rationale should essentially be, does it uphold the standard of care? Is what the AI is saying I should do within the standard? Because that is the role of the clinician to determine the standard. Informed consent and data privacy, we've talked a lot about that. I think it's pretty evident, patients need to know what they're interacting with, and they need to be given informed consent to that interaction. And they need to know that their data is being kept private, that is being secure, that it's not being used, or if it is being used to train the models, they're aware of that. And so there really need to be an informed discussion about this use of AI in their care. Physicians have a responsibility to identify and mitigate potential biases. And I've already mentioned, that those biases aren't necessarily in the models, but that doesn't remove them or eliminate them. And it doesn't eliminate the responsibility in the clinician when they know they're seeing something that doesn't make sense and it has a biased nature to it, to identify it. Once you know a tool isn't accomplishing the thing you needed to accomplish, it's no longer safe to use that tool, especially if you know that it exists. And so, working with developers within health systems to identify that bias and make sure that feedback goes up to the developers is extremely important. As I mentioned, these tools are far too advanced for boards and really clinicians to dive deep into this stuff. You may have heard a lot in other presentations about what's called a black box. It's really hard to crack those open and then get into those and figure out what's going, if not impossible. So really, we have to focus on making sure that those AI outputs make sense. It's not ideally, I do believe, just anecdotally and from the advances that have been made in the research, that one day we may get there and be better at understanding what was going on to lead those outcomes. But we know the data sense. We know enough of the science to understand how things work. And so when an AI gives an output, it's the ethical responsibility and the professional responsibility of licensees to make sure they're only carrying out those instructions and directives that make sense. And so rather than attempting to regulate specific AI applications, boards should really focus on governing AI use through established ethical principles. And then lastly, collaboration is key. Collaborate wherever. that whether that be on education, development, enforcement. Only by collaborating and understanding how these models work and providing feedback can we really move these things forward. So I'm going to skip through these last section slides just for time. These slides talk a little bit about the future of AI, and these are really more about some of those models and tools and practices that are kind of coming out. This is Hume AI. This is a voice AI. It provides some pretty impressive and kind of scary conversational empathic AI, meaning it can detect your emotions from your voice and provide some kind of talk therapy services. It's these kind of models as a regulator that I am most concerned about out there because emotional response, people with mental health and emotional issues tend to be the most vulnerable. And so these tools are in the space that I think could have the most chance for risk, but also serve quite honestly some of the greatest good. This is pathology. This is just referencing some work in the pathology space, which is another area. Imaging is another area where these diagnostic models and these generative models are really excelling. And I think it's one of those areas where the standard of care is going to flip pretty quickly towards the use of these models to really provide the best care. This is an example of a tool that I have been developing and playing with as a proof of concept here at the Federation. And this is a tool for boards that could really just an AI that could help triage complaints, ingest a complaint, such as this example, and then provide an output that determines the jurisdiction, the names, and summary of the complaint, and really kind of
I've
what's
got like
going on.
3 more minutes.
Just call me.
Okay.
Or come back.
And then
Okay, yeah, thanks.
here is an example of a chatbot that is being used by the District of Columbia Department of Health. You can go to their website and you can interact with the chatbot and ask it questions. Here are some examples of information about the District of Columbia Department of Health that I had just asked some information about, and then it can provide it to you. And again, I mentioned earlier about needing to ground these tools in that, and this is what these chatbots are starting to do. It's called it's known as retrieval augmented generation, or RAG. And essentially it's basically saying to these models, don't just pick an answer out of the ether, but pick an answer out of this material, sort through this data set and find what it is I'm looking at. Because it's when we ask it to kind of take things from its own knowledge base that it tends to make these hallucinations. So I'm going to leave you with a few takeaways. Understanding, this is really highlighting everything we've already talked about, so I don't really expect there to be a whole lot of new things here, but I really want to summarize our major takeaways of what we've covered today. On understanding the trends in state AI policy reforms, the current landscape, many states are already implementing laws and regulating and regulations regarding AI, particularly in sectors like healthcare, but that this is a patchwork approach. And I do think that there will be inconsistencies and that sooner or later a federal law will be necessary. But that for right now, we're seeing some key reforms. States such as Utah and Colorado are leading the efforts to protect consumers. We referenced Senate Bill 149 and Colorado Senate Bill 24205, but we have California, and I'm sure we'll have others here in the very near future. And then we have federal involvement. While the U.S. is still in the early stages, the EU is moving forward with comprehensive AI regulations, and I expect we will eventually see an overarching bill, but there is still federal movement in specific agencies. So it's very important that you and your industry keep abreast of, if you have a regulator that already regulates your space, reach out to them and ask them what they're looking at in AI and are those regulations, policies, or best practices are they looking to put out there? Because while there are not necessarily a lot of regulations, there are a lot of policies. And I'll throw out a state out there, Washington State. The Washington Medical Commission is working on a policy related to the use of AI by clinicians. And so I would strongly recommend anyone out there to look at your direct regulators and reach out to them about those regulations that they either have or that are in the development pipeline. So what about the impact on healthcare delivery? Well, I think we went through that a lot. We've noticed that there's definitely a lot of room for efficiency gains. A lot of the AI is being used in various ways, from transcription tools like DAX and Augmetics, to being used in pathology and radiology, such as IDXR or those pathology tools that I mentioned. And we're also seeing, the success in some of these models, or the purported successes, I should emphasize, has demonstrated That they arguably can pass these exams. Again, I'll emphasize arguably, but it does suggest that AI is going to play a growing role in clinical decision making. And it's already out there in many cases, but that role will continue to grow. And so it's very important that providers be aware of of what role AI is playing in their decision workflows. And that leads us to our last part on this, on the impact of healthcare, is the cautions for practitioners. While AI tools provide support, providers are still accountable. And so again, proper documentation is really, really crucial about whether you're following or deviating and the reasons for it. Some practical strategies. We talked about practical strategies to stay informed, update your understanding of both your state and broader national guidelines. Make sure you're staying up to date on those ethical requirements, and that you're proactive in ensuring that those systems that you're using in the AI space are free from bias, and they really should prioritize patient autonomy, informed consent, and non-maleficence in those spaces. And then education continues. We encourage continuous education at all levels, and we really, really do believe that education at the graduate level is going to have to start including some of this stuff. And then lastly, tools and resources for staying up to date. Work with state medical boards, healthcare organizations, and technology providers to ensure that AI tools are used responsibly. We at the Federation in the healthcare space, we have a lot of policy guidance, educational programming, and we do provide assessment services. And there are an exorbitant amount of technical resources out there that I didn't include because there's just far too many. But if you're interested in learning more about the technical aspects, I highly recommend you check out some educational resources from Google, Microsoft, and then there are some websites out there like GitHub and Hugging Face, which provide a lot of models, but those are in the very, very technical side. So unless you're really looking to learn more about coding and programming, I would probably stay away from those sides. And so that I will end. I will leave it open to any questions, and that's right there is my contact information, my email, and my LinkedIn profile. I will stop sharing. I see some questions. I don't know if we have time, Lydia, if you want me to go through the questions real fast. I know we're past time.
Sure, yeah, I see a question or two in the chat, if you would like.
Sure. I'll just go over them real quick. So I see, and I apologize if I butchered anyone's names, Malik Shaw. As a model developer, I'll contest the notion that garbage in, garbage out is true for LMs. You need the garbage to go in so that you can train the model. Conversely, you have a pristine, unbiased data going in. This true. I should emphasize that part of the training is teaching it what's wrong. You need to show it what is right and what is wrong. There is something known as the models will overcorrect themselves, or they get an idea of what is perfect and they won't deviate from it. Like they just stick to that. So you do have to give it some bad examples. But when I use the term garbage in, garbage out, I'm referring to the entire quality of the data set, that you're not even including those examples, that you don't have the annotated, proper annotations about what is right is what is wrong. From Quinn Sheen, in addition to SB 1047, California Bill AB 3030 is with the governor and some of the Utah requires transparency and disclosure as to Gen AI in the healthcare context. This is a bill that applies to healthcare deployers, end users, physician offices, health systems, etc. Thank you for that, Quinn. California, I'm sure, and again across the state, there are a plethora of bills that have been introduced. It's interesting to see which ones actually make it across the finish line, which still has not been a whole lot. But I would emphasize a lot of policies. There are a lot of policies. So very important to check with your specific regulators. And then lastly, from a Joe McMenamin, and again, apologies if I'm getting these names wrong. Some scholarly commentary calls for licensing AI where its function resembles the practice of medicine. Notwithstanding that, at least so far as I know, physicians retain decision-making authority in all circumstances. Proponents point to the definition brought in many states of the practice of medicine as well as consumer protection goals. Does it appear to you that U.S. state boards are likely to impose such a requirement, and if so, how? I don't know. It's not. Are there boards that think such a requirement would be useful? Yes. The problem is going to be that boards generally aren't the ones who introduce the legislation. Boards will pass the rulemaking pursuant to their statutory authority. It's the legislatures that will pass those statutes. And the problem with creating a licensing structure, California is trying it though. I mentioned that they're creating that board of foundational models. The process is twofold. One, or the problem is twofold. One is the level of understanding you need to have and education, which is very, very unlimited. It's much in limited supply right now. So it's getting the proper people to staff that at a state-based level, because each one is licensed at the state, at least in healthcare. So every state would need that expert, which I just don't find happening. But then two, getting access to that data. A lot of it's proprietary. I doubt the developers will push back real hard. But I agree with you about the definition, and this is something that I've advised boards on, is that they really do need to look closely at how they define the practice of medicine, and to talk with their attorneys and really just gamify it out, play it out. If you had an AI model, if CVS came in right now and stuck a AI doctor kiosk in their clinic, what could your board do? What would your board do? And it's just fully independent. It has a conversation. It somehow has prescribing authority. It's spitting out pills. It's a magic box. But just from a regulatory hypothetical, if it could independently do those things, what authority do you as a medical board have? You regulate licensed professionals. Some boards, though, also have some authority to seek injunctive relief or other equitable sanctions to try and stop that. Would that include such an entity? And if not, does that need to be addressed through the definition of the practice of medicine or through some other schemes? I don't think the short answer to all that is right now, I don't think we're at the space of licensing individual models. I don't think and I don't think it's going to be possible long term. I think we have to continue to rely on licensing those institutions and individuals that are the gatekeepers to care, and ensuring that they are responsible for those areas that they are responsible for. So there's a long-winded answer to that, but that's how I see things, at least in the short term, unless OpenAI comes out this week with a truly, they've broken through and they've discovered AGI, which if any of you in this space have been following, Sam Altman made a very odd website post recently, and some people are like, they've made AGI. I don't believe that, but I think he's just being a weird tech bro. So I will end it there, and I am happy to answer any other questions or anything else that anybody has.
Great. Thank you so much for taking the time to talk over this issue. I know I learned a whole lot. And thank you, of course, to everyone who joined. We will be providing a copy of the slides as well as a recording of this webinar afterwards. And again, thank you all for coming, and I hope you have a great rest of your day.